Okay, let's dive right into this explainer and set the stage for dissecting a really complex legal paradox. We are talking about digital free speech, criminal law, and justice. Today, we're going to unpack the legal autopsy of a very specific case involving Dr. Chen Jinyaran. His conviction for spreading fake information online sparked a massive legal debate, and we're going to break down his structural defense, a defense that strikes right at the core of how criminal law interacts with our digital expression. So think about this for a second. Can a political cartoon be classified as a fake fact? I know, it almost sounds like a riddle, right? But this is the central, real-world legal dilemma derived from Dr. Chen's defense. I mean, if a cartoon is just meant to be a metaphor or a piece of satire, can a court legally judge it as true or false? Now, this isn't just some abstract philosophical thought experiment. If you use social media to share memes, art, or just everyday opinions, this absolutely matters to you. Because in the context of criminal law, where spreading quote-unquote fake information can literally lead to imprisonment, the answer to this question defines the absolute boundaries of our free speech and legal liability. Here is our roadmap for today's legal autopsy. 1. The core legal dispute. 2. 4 categories of speech. 3. The burden of proof. 4. Measuring the consequences. And 5. Boundaries of the law.
Let's jump straight into part 1, the core legal dispute.
To truly understand the defense's argument, we first have to look at how the judicial system approached the initial conviction. In criminal law, fake information has a very strict, specific definition. It must be a falsifiable factual assertion. Basically, this means it has to be a claim about the objective world that can be definitively proven true or false. Like, if you post a bridge collapse today, well, that either happened or it didn't. This strict definition is the absolute anchor for this entire case. But here is where the legal dispute really heats up. The prosecution in this case utilized what the sources describe as a bundled charge. So over a period of years, the defendant made these sporadic, low-engagement reposts of all sorts of different content. And instead of verifying the objective falsity of each individual post, the authorities packaged these diverse posts together into a single overarching crime of spreading rumors. The defense argues that this completely bypasses standard judicial proofing. You can't just throw a bunch of random internet posts into a giant bucket and label the whole bucket illegal without inspecting the contents one by one. Which brings us to a fundamental principle of criminal law. A collection of non-criminal acts does not equal a crime. The defense's critique of this bundling tactic is pretty straightforward. If one individual post is just a harmless opinion and another is just a piece of art, adding them all together doesn't suddenly magically transform them into the crime of spreading a factual rumor. All right, moving on to part 2, 4 categories of speech. To dismantle those bundled charges, Dr. Chen's defense brilliantly sorted all the posts used as evidence against him into 4 distinct buckets. Category 1, art and aesthetics, so things like cartoons and poems. Category 2, subjective emotion, like expressing sadness or anger. Category 3, rational opinion, like political analysis or academic views. According to the defense, these first 3 categories are all value judgments. They literally don't possess a true or false property, so they are protected mental expressions. It's only the 4th category, objective reality, that actually deals with verifiable facts. So focusing strictly on that 4th bucket for a moment, objective reality. This includes things like news reports, historical data, and event descriptions. The defense argues that this is the only category that can legally be scrutinized for truth or falsity under criminal law. I mean, you can't put a cartoon on trial for being fake. You can't put a feeling of sadness on trial for being false. By separating out the art, the emotion, and the opinions, the defense drastically narrows down what the court can actually legally evaluate as a potential rumor. Let's shift gears to part 3, the burden of proof. Now we turn to the subjective elements of a crime, specifically focusing on the legal requirement of knowing, as in knowing that information is false. When an everyday citizen clicks repost, do they have a legal obligation to conduct a professional fact check? The defense firmly argues no. There is no law requiring ordinary citizens to act like investigative journalists before sharing a post. Contrast that with the state. The state actually has the statutory mandate, the authority, and the massive resources required to police digital information and officially debunk rumors. Shifting this huge burden of verification onto the average internet user, the defense claims that creates an impossible standard. The prosecution leaned on a pretty major assumption here. They argued that because Dr. Chen is a highly educated PhD holder, he should have known the information was false. But high education does not equate to criminal intent. Criminal law requires explicit proof that the poster knew the information was fake and intentionally spread it anyway.
You absolutely cannot legally substitute hard evidence of criminal intent with a presumption based simply on someone's college degree. This brings us to Part 4, Measuring the Consequences. Even if a post is objectively fake, and even if the poster explicitly knew it, the statute requires proving an objective result, actual real-world harm. For a cybercrime conviction to hold up, there must be a completely unbroken three-step chain of evidence. Step 1, the information is objectively fake. Step 2, the poster explicitly knew it was fake. And Step 3, the post caused severe public disorder. If any single link in this chain is broken, the legal analysts and our sources argue that the crime simply does not exist.
And here is what the defense calls the missing link of consequences. In partially reporting the facts of the case, our sources highlight a complete lack of measurable evidence for severe social disorder. There were no public riots, no societal panic, no paralysis of public services. The poster had fewer than 100 followers, and a lot of those were inactive accounts anyway. There is, quite literally, zero empirical evidence of chaos. The defense questions how a crime demanding severe social disorder can possibly be finalized when the real-world impact was practically non-existent. Now, here is the ultimate irony brought forward by the defense. The very posts labeled as highly dangerous rumors, the ones that allegedly caused the severe social disorder, they're actually still online. Yeah, they have never been officially deleted or even debunked by the authorities. If these posts were truly that catastrophic, wouldn't the authorities fulfill their duty to remove them? The fact that they still exist on the internet severely undermines the claim that they are dangerous rumors. Which leads us to our final section, Part 5, Boundaries of the Law. We arrive at a foundational pillar of modern justice, nullum crime sine lege, which translates to no crime without law. It strictly forbids the punishment of acts that are not explicitly outlawed. The defense uses this principle to argue against turning specific online regulations into a vague pocket crime. Because think about it. If the courts blur the lines between verifiable facts and artistic expression, and if they eliminate the need to prove actual harm, well, then the specific law against spreading rumors becomes a giant, boundless pocket into which almost any unapproved digital expression can be dropped. So, I want to leave you with this final, genuinely provocative question. It perfectly encapsulates the legal paradox we've explored today. If undebunked posts with practically zero engagement can legally be declared the cause of severe social disorder, where does the law end and the regulation of thought begin? This case isn't just about one person's social media feed. It's a profound stress test of the legal boundaries between internet regulation, criminal liability, and the protection of free expression. Thank you so much for joining me for this explainer. Keep questioning, keep learning, and I'll catch you on the next one.